I think meeting stopped in between uninterrupted. Yes, sir, you are audible, sir. Yes. Yes, yes, no issue, sir. Yes. 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 Yes, yes, I will give them brief introduction what is IPR, and then I will discuss about the meeting aspect. Thank you, sir, for inviting me for a session. So, is this my screen audible to everyone? So, my name is Vinay. My name is Vinay. I'm a lawyer, and I practice IP matters, more particularly to patents, trademarks, designs. I am one of you because I'm also a BTech in computer science and engineering. So I will start what is IP and then how we can protect our IP rights. Okay, so this is the major session, and then we will also go through how we can have a like what are the steps in patent protection. And for instance, if you are going to file a patent, what are the steps that you should consider while filing a patent application? So we can go on all these aspects, and later on we will have a question and answer session. So to start with, so should we have an interactive session if any one of you have any queries in between, do let me know so that I can address you in between. Okay. Am I audible? Anita, am I audible to you? Hello? Anita, am I audible to you? We will have an interactive session wherein I will explain. So if they have any queries in between, they can let me know, the students. Is this fine? Yeah. So if anyone has any queries in between, do let me know. So to start with, so what is intellect is, so once you go through a normal dictionary meaning, so it is like an ability to think in a logical way and then understand things. So it is something like what you create by your own intellect of mind. That is something what is called intellect. And then so what is intellectual property? So intellectual property refers to something created by your own mind. So example, if you so what can be creation of your mind can be say like inventions, which are related to patents. Like if you have say made an electric car, so that is subject matter of invention because earlier there were no electric cars, but you have made an something a car which runs on an electricity. Okay, so this subject matter can be is an invention and can be protected under the patent acts. Now, what are the other aspects we can have a protection is inventions, literary and artistic works. So, what is literary and artistic work? So, literary and artistic works means something like when you write a book, when you are painting. So, this is also a creation of mind. So, anything which you create utilizing your mind is called intellectual property rights. So, there are different aspects. One is say inventions, literary and artistic works, designs, symbols, name, and images which are used in commerce. So, what are, say, example, what are symbols, names, and images used in commerce? So, symbols, name, and images are, say, example, you are out in a market and you want to have a coffee. So, you have a different, uh, say, indication as to who is the service provider. For instance, if you're going to have a tea in a mall, So you have either you can go to a CCD, you can go to NBHI wala, or for instance, you can go to Starbucks. So all these symbols resembles that they have certain specific quality of services, and it gives a specific, say in a commerce or a trade, it gives an interrelation that this entity is owned by, say, this coffee. If you look as a Starbucks, you understand this is from the Starbucks coffee, and it will have some specific properties, or it will have a specific, if you go to Starbucks, it may have some specific services which you would like. So this is how we can, like, say, protect our intellectual property rights within the different aspects, like which can be spanned through, like you made a some new say car or any artistic works, design and symbols. So this is what is called intellectual property rights. So I have given you example. If you look into my the present, see, if you see, this is invention. Why this is invention? Because this invention has been filed for a bulb, and you can see. Let me zoom in. So you can see this patent was filed by Thomas Edison, and it will show an year of 5 September 1882. So in that year, so if say this patent has been granted, this patent was granted. So this manufacturing of this specific bulb will be done by a specific owner or any licensee which have right to produce this bulb. So this is one of the example wherein you can see this. If you have developed something new, you can have a protection. For instance, when, say, example, in your field, say you are in a computer science and engineering background, so you may think of, like, say, a robotics. So you can get a specific protection for robot if you have designed something. Like you might have seen, there are different robots which can be automatically driven, or which are AI based robots. These are one of the, say, application wherein you can contribute, or you can have a technical effect, or you can make a machine which have specific working, and then you can protect it. So all these aspects, when you create something new which is based on having a technical features, that comes under the invention, and it can be protected under the patent acts. Now coming to, say, patent is one thing. Now say someone who is good in writing. So what he can do, he will write, he or she will write a book. So this is also one of the creation of the mind. Now in this, say, one can copy a specific, say, writing of a book. So that is how you can get protection on a literary work. Now designs, can you see my, is this screen visible to you? Swati, is this screen visible? Yeah, and am I audible? Let me know if you have any queries. Now coming to the design protection. So if you go to, say, I'm giving one of the example. If you see a Bisleri bottle, so I have a specific design, or you if you go and have a water bottle of Aquafina, so it is also having a specific design. So this design which is having an aesthetic appeal to your eye is subject matter of designs act. So anything new, like, for example, if I have given you example wherein you can see this design is of a Titan wristwatch. So they have filed a design application wherein you will see this specific chain, and then they design. So you will see no one else, for instance, if they filed in India, will have this specific design, which is related to only Titan Industries. So no one else can copy this design. If someone copies, they will file for infringement of their rights. Now coming to the names, like how you can protect a name. So something like if you have developed a, say, you have thought of a new name, for example, Tanish. So this is Tanix is a brand name, for example, related to Tata. So if you coin this name, you have a protection of this name. So no one can copy this name specifically. So let me summarize. What we have done as of now is we have gone through the inventions, which can be subject matter of Patents Act, literary and artistic works, which can be subject matter of Copyright Act, designs, for example, a design of a bottle, watch, or design of a car, anything which have an aesthetic look and feel is subject matter of Design Act. Now coming to symbols, name, and images used in commerce. So anything, for instance, if you use any name or any symbol which is used in commerce to indicate the source of good or services is comes under the ambit of Trademarks Act 1999. So these are the measures act under which you can have your intellectual property protection. There are various other acts also, like like if you want to have protection for semiconductor, it have a semiconductor protection specific act where you can protect it. But mainly, if you look into a general, working, so these are the measures act under which you can have your intellectual property right protection. So now I will take you through specific, sections wherein how you can go for patents, copyright, designs, and trademarks, and then later on we will specifically focus on what is the Patents Act, like how we're going to protect the Patent Act. So now coming to what are intellectual property. So as we have illustrated earlier, so once you have created something, so you want to protect it so no one else can copy it. So because these, if anyone is allowed to copy, you will not produce any new work. So what are intellectual property? So intellectual property are similar to any other rights, wherein if you have intellectual property rights, you have a right to license, assign, and transfer. And say it allows creator or owner of these right to benefit from their work or from their investment which they have done in development of any new invention to reap benefit out of it. Why? Because why this is needed? Because, for example, if you say a designed, say a new car which have a specific feature, like it can say a car which is having a battery which can go for around 700 kilometers in one charge. Now this, during this development of this specific battery for a car, you might have invested crore of lakhs of rupees for developing the specific battery, because you might need some researchers, some other inventors to develop a new product. So if you are not given a right to protect the investment that you have incurred during development of a new product, so you will not come up with new ideas, or you will not come up with the new products or process in the market. So that is the reason why, if you develop something, so there is a protection which can be granted to you, so that you can reap the benefit out of what you have created. Now once you have created, what you can do, for example, if you have patent, if you have design, if you have copyright, what are the rights that you can do? So one of the rights that you have is licensing your IP. So licensing means that if you are the owner of the IP, you can license, say, someone else to develop it. That is one of the ways wherein you can reap a commercial benefit out of the IP. The other things is, what you can do is you can assign the IP rights, you can transfer your IP rights, and then you can reap the benefit. So these IP rights are generally similar to other property rights which you have. So you have licensing, assigning, and transferring rights. Now coming to question, why promote and protect intellectual property rights? So the basic question is, for promoting and protecting intellectual property rights is to have an economic growth. So example, if you are not getting a protection for rights which you have done, let's say country like US, you might see why they have a strong IP protection regime, and that is the reason why they have grown in technical aspects. So promotion and protection of intellectual property rights gives growth to economic. And when there is economic growth, there is creation of new jobs, industries. It also enhances your life. For example, if you get a new car, which is something electric, it has an automatic door opening. So it enhances your life and doing something of what you are daily doing it. You may take an example of robots. So now, because you get a protection on AFI, right? These, say example, you might have cleaning robots which can go and clean your home, or these robots can be installed in malls which can go and clean the floors every time without any human intervention. So these are the basics why we need to promote and protect the intellectual property rights. Then, so the question is, we are giving these rights, but how the average person, like say average person like us, how we are going to benefit? So example, if you say, take an example like in the copyright or for a movie. So example, if you don't get a protection for a movie under the Copyright Act, so you will not be able to see, say example, you may not be able to see a 3D movie. So people may say like 3D movies like Avatar, they have invested a lot of money in making a movie itself. So if they don't get a protection, they will not invest a huge sum of money in producing such movies, and that is how. So these rights are protected. So average person gets a benefit by having or utilizing these products or any creative things which has been developed by any author or inventors. So this is one of the example, like Avatar movie you might have seen. So this is, they get protection in the Copyright Act. They have invested a huge amount of money. When this movie has been under copyright protection, people will take license, and who is the only license holder? They can say show this movie in their theaters. So that is how you reap benefit, and you are going to enjoy as an average person. You are going to benefit and see new creative things. So this is again like, so why the average? So one example we have given a movie. Other example is say you can have a say cleaning robots, or you have automatic cars. So these are one of the mechanism wherein you get average person get benefit from the IP innovations that are being done. Again, say example how the benefit is done, like say, because for example, if this design of an apple is being protected, you always get a new design from Apple. They have new softwares, because all these things they either file for, if something is technical, they file for patent protection. If something is for aesthetic part, so you have the design protection. So you will not see that any other mobile will have same design and the placement of the cameras in the market. So these rights are jurisdiction rights. So if, for instance, the Apple has filed the design, the look and feel of Apple, you will not see any mobile which is having the same look and feel. Example, in the same camera placement, you will not see any of the mobile having. You may see people may have different design where they can put two cameras together, but this three lens you will not find it. As of now, you can go and see and check. You will not find exact similar which Apple has done. So this is how we benefit if something there is an innovation in an industry, and people like us benefit from the innovation by the authors or inventors. So, so this is what is the basics of say IP rights. So now, as you might have understand, we have four aspects. One is inventions, which requires a technical thing. So, example for patents, like if you have developed a new car, so which has some technical effect. For instance, you might have developed a new robot, a self-cleaning robot, or any other robots. So these are subject, because these involve technical aspects, they may be subject matter of patents. Similarly, if the design of a robot, look and feel of a robot is something new, you can have dual protection. You can have a protection for technical part, you can protection for look and feel, that is in the Designs Act. And third, if the robot is sold under a specific name. For example, if my robot's name is Zuzu, for instance, this Zuzu will have a protection in the trademark act. So we can have three type of protection on a single product. So for technical part, that is patent act. For look and feel, we can have under the designs act, and for the symbols name which indicate the source of a product, we can have the trademarks protection. Now, the fourth is the literary work, something like, say, if you have written a book, movie, artistic works, these are subject matter of the copyright protection. So these are the major four acts or four type of intellectual property rights that are generally used. There are other aspects also which we have not dealt here. Those can be also your IP rights can be protected under different statute. Now coming to what is a patent, because we have discussed as of now, like we can have a protection for invention. So invention, like we have in the previous slide, we have seen that there was invention for a bulb which got protection. Similarly, we can have a protection for any new electric cars which require technical aspects. Drones, if you see drones are there, they get protection, patent protection for drones. Robots, these are the upcoming industries. In robots, they have patent protection. Any other new mechanical devices, they have patent protection for uh, operating a new, say, if you have generally take an example like the telecommunication devices, there may be 4G technology, 5G technologies, and there are different aspects how the communication between the users are happening. So these are also the subject matter of patent protection. So what is patent? A patent is something which gives grants an exclusive right for invention. So invention can be two types, can be broadly classified into two types. One is a product, something like, say any machine is like a product. Process means like you have steps one, A, B, C, and D are the process patents. So how this process patents and products are different. So product is something for a new device and apparatus. Process is steps. So example, you might have a method of doing XYZ. For like method of preparing a tea, wherein this tea might have a specific novelty and inventive feature. So this may have a patent protection, or a method of doing something X, a method of, say, conducting a search, wherein you might have you might increase the processing of a memory. So these aspects, like methods, can be a subject matter of patents. Now, coming to the Patents Act, what are the major requirements of this to get a patent protection? One thing is it must be an invention. Invention means something which belongs to any field of technology. So invention is, it should be related to a technical field. Now, the second aspect is it should have an industrial application. The third part is it should be new, like it should not be something which is already existing in market. So say something which is already there and you want to have a protection, you just say go and copy it and you say this is my new product, because that is already existing in the market. And say other thing is the fourth aspect is the inventive step. Like, say, it should not be like there are four different products which are available in the market. You go and combine all these four products into a single product, and you say this is it will be a new, but it will not qualify inventive step, because what you have done is you have say taken different products which are already available and just combine it together. So something inventive step is something called is called it should be non-obvious. Means like it should not be obvious to person is something else. Like it should be like, say, if you see, for instance, is there was a robot for cleaning a floor. Okay, now what you have done is modified it a robot for cleaning glasses. So what you've done is, despite of the fact that it was cleaning the floor, you have only changed from the below part, you have made something which can be afflicted and only can clean it with no other aspect. So I'm just giving an example, a layman example, wherein something was already existing, you just made an obvious changes to it. So it will not be a subject matter of a patent protection because it does not involve inventive steps. So this is the criteria when you are looking for a patent protection. So these are the criteria generally. Three are the major criteria. One is something which is related to technical field. So these new inventive step and industrial applicability. So these are some of the criteria for your patentability requirements. Now coming to, so what is trademark? So once we have given say a distinct still in a previous slides we have given example of Tanishq. So what is Tanishq? Tanishq is having a distinct sign which relates to specific good or services provided by an individual company or by individual. So by referring to the specific name and symbol, you know that what is the source of this product or services coming from. This is the crux of Trademarks Act. So if you go and buy, so if you're purchasing from e-commerce websites, so Flipkart or Amazon, so you know this type of service will be from Flipkart, this type of service will be from Amazon. So you can easily identify what is the source of that company which is providing that specific services. Examples are like, say, if you can see, this is um, Nike designs and then McDonald's designs, Tata designs and Mercedes Benz. So these are the specific sign which know that this source it will have a specific quality of services or goods when you are purchasing these services. So you already know. So if you are purchasing from this specific brand, because of the indication as to source, you will know what type of or what quality of services you are going to receive. These are related to health if you go to health industry. Now coming to designs, something which is ornamental or something which is having an aesthetic aspects of an article, so these come under the design sector. As I've already told, like you can, if you know, you see the Bisleri bottle or Ecofina bottle, you will understand that this is the specific design of that product. And say example, if you go for purchasing a jewelry, you will know this jewelry is a very attractive design. So you can get a design protection on it. So anything which is appealing, which is aesthetic, can have a you can have a protection on the design side. As even this is a design of an apple, which you can go and have a protection. The design of a Coca-Cola. So earlier, if you see the bottle of Coca-Cola, it would have a specific design. If you can look into, you will still remember that these were the bottles which were earlier present, and you know that this, even if say for example, if you were not able to see the logo of Coca-Cola on the bottle, you will understand that this is from Coca-Cola. These are the new bottles which are coming up with the design which is have a specific indication as to impression. Copyright, as previously told, that literary and artistic works comes under protection of copyright and related works. And for, like, say, if you've written a book, if you've written, say, one of the say computer programs codes are protected in the Copyright Act. So if you've written a new code, so the code something is for qualifying a criteria, say under the Patent Act is very stringent. So computer program per se are not subject matter of litigation. But in copyright, if you have written something new from your, the code can be protected. In the examples of copyright is anything like novels, poem, plays, any advertisements, films, musical composition, choreography, paintings, drawings, photograph. These all are subject matters of copyright. So anything which say you do, like say write some new books. Say example, if you write a technical book, for instance, if you see some professor's book, you will find it will have a copyright symbol because they have written it, invested their labor and their expertise in developing that book, and they can have a copyright. And once these books are being sold, like professor books are being sold, they give royalty, or they have the specific agreements between the publisher or the author how they will benefit from the sale of the book. So this is how the one of the aspect you can generate a revenue. Now coming to uh, the Patents Act. Uh, so it defines what are not invention. So then, for instance, I right now I will take an example of a syringe. So, and then I will take you through one of the example is called computer program passage under section 3K. But here in what are not invention is say any process of medical, surgical, curative. Because to explain you in the basic form is any say this the Patent Acts in section 3, they have criteria what cannot be treated as an invention. So, for instance, one of the criteria, section 3I, states that any process for medical, surgical, curative, provided diagnostic, therapeutic, and other treatments of human being, or any process for a similar treatment of animal to render them free of disease or to increase their economic value or that of their product. So this is not subject matter of patent protection because, say, if you have developed some new surgical method of curing someone, so anyone else cannot use it. Correct. So this is not a subject matter of patent. The reason being, what are the other thing is now what you will see the robots are being developed. So the robots can be protected, but if you have developed a specific process, say surgical or process, it will not subject matter of patent protection. But so you use the technology, you also can, so you can you for instance you patent protection on a robot, how this are doing say surgery because it by the patent set. Now, similar thing is there under the, like say, I have given an example of the one of the simple examples wherein patent can be granted. Say any process. Last time we told you that there is you can get a protection for product and a process. So products example, I have given example car, say any robots, any other mechanical devices. These are subject matter of patent protection, and process is also one of the patent protection. But for instance, if this process is related to surgical method, it will not be a subject matter of patent protection as this is barred. What are not inventions? It is barred as per the Patent Acts. Now, similarly, coming to your area of interest is Section 3K of the Patent Acts. So, Section 3K of the Patent Acts describes, let me just read it for you, is a method, a business method, or computer program per se, or algorithm. So, something which is computer program per se. So, computer program per se is not subject matter of patent protection. But there are different invention wherein say computer say you have developed some say programs example for a robot or something which works in conjunction with the hardware element and have some technical effect, it is subject matter of patent protection. But computer program per se with no technical effect or say technical contribution is not a subject matter of patent protection, is not subject matter of invention within the meaning of it, and it is not eligible for patent protection. That is one of the examples. Now coming to, there are different other like say I have given example like under the Patent Act section there is section 3F which states that mere arrangement or rearrangement or duplication of known devices each functioning independently of one another in known way. So, example, if there was a robot for cleaning something, and it was not able to move. So, and earlier there was say a moving machine. So, example, you have taken two parts. There was already existing machine which can move, and there was a robot which can go and clean. So, what you've done, you've merely arranged the two things together and made a new product which can move and which can clean also. So that mere arrangement or rearrangement or duplication of known devices or things which are already present earlier, so it is not subject matter of patent protection. So I will just explain what is the patent filing and prosecution procedure. So once you have say got an idea that you will develop something. Say we will take an example of a robot because it is related to your field, for instance. So robot is so you got an idea that you want to develop a robot for cleaning, say robot for cleaning your say premises, for instance. Okay. Now what you will do is so one of the process is robot for cleaning the premises. That is, you have thought an idea that is robot for cleaning premises. This is an idea. So under patent protection, you will not get a protection for idea. You will get a protection for invention. So ideas are not subject matter of patent protection. Inventions are patent protection. So you got an idea for a robot for cleaning of the premises. That is an idea. But what is invention? Invention is something specific. How the robot will be there, what are the different elements. So robot may be having a x y and z features. Okay. Now these features of working together is your subject matter of patent protection. So you have developed one robot for cleaning, I can also develop a robot for cleaning. We have a same idea but the inventions are different. So I will, if my invention is different from you, what you have done, for example, if you have a features xyz and I have a features of a b and c, so these two are totally different inventions altogether, and we will both get a patent protection even though the idea is robot for cleaning. So robot for cleaning is an idea, but what is the invention is invention, how, what are the different features of your robot for cleaning is your invention, and invention is for specific elements. In a Hello, can we start again? So I have few slides, and then thereafter we will have a questions and answer session. Okay. So, what is the patent filing and prosecution? So, patent. So, once you decided to go for a patent, what we were discussing in the prior, just before the meeting ended. So, you get a patent protection for an invention. So, inventions, your invention for, say, a robot for cleaning will have features X, Y, Z, and I also made a robot for cleaning, but my features are A, B, and C. Both will get a patent protection because these are two separate invention altogether. Even though the idea is a cleaning robot. Now, once you get this idea, what you do is first you see that is there something already available similar to this or not. So what we do, we conduct a prior art search. So prior art search is, it is people generally do. So there may be possibility that people don't do a prior art search. But why we do a prior art search? We do a prior art search to ascertain whether same or similar patent is not already filed or granted. Even we search for patent literature and non-patent literature. Patent literature means so patent documents which are already filed. Non-patent literature means anything which is already being published, like research papers, any book. So the prior art search can be categorized into two things. One is the uh, patent literature and non-patent literature. So once you conduct a prior art search, thereafter you draft and file a patent application. So once you start drafting, so what you can do is you can draft a provisional patent application, wherein if you're still in phase of the developing your inventions, but you want to have a protection on it, you have not totally done a complete research or you have not completely finalized it, but you know what are the specific elements that will be in developing a product or a process. So what you do at the time of when you conceptualize the invention, you file a provisional patent application. So what you can do is, for filing one is provisional patent application, and within 12 months, when you complete the research, you file the complete patent application. So there are two types of filing. One is provisional patent application and complete patent application. Now, so once you have already conducted a search, then once you have found that there are no existing prior art which is similar to your invention, what you have developed, like say features like X, Y, and Z. So what you decided to is you decided to go ahead with filing of the patent application. So filing of the patent application can be of, say, two types is, once you have not say fully developed a product, you are still in research phase, you do original patent filing, or you have, if you have developed a product, you will do a complete patent filing. Now once you have filed the patent with the patent office, what patent office does is patent office examines your patent application. So this, what patent office does is patent office have the controllers, examiners, and what they do, once you file the patent application, they will examine whether the claim. So one of the crux or heart of the patent application is claims. So claims define what is the scope of your invention. So as we were discussing is, if you developed a cleaning robot and your cleaning robot has features X, Y, and Z, and these are the X, Y, and Z are the novel features. So you write in your claim, say example, a robot for cleaning premises, for instance, and then comprising of these features, comprising X, Y, and Z. Now, once you file the patent application at the patent office, what patent office does is they examine the claims, and they go through your description and they examine the claim, and they based on the claims you define the scope. So this is your boundary of your patent. So you will not go and claim, say if you haven't written A, B, and C features in your patent in the description and in the claims. Now you can't go and add something new after filing of the patent application. You can't change the scope. So in the layman's terms, you can't change something which you cannot add something new to your patent application. And technically speaking, it is something like you can't change the scope of patent application. So if you have claimed features X, Y, and Z, and you haven't claimed written any features related to A, B, and C, later on you can't claim these features. Now this X, Y, and Z, the based on the features and description, the patent office examines it, and they will do their own search now, whether something is already there to, like for example, we prior we have seen the patent criteria is uh, novelty, inventive step, industrial applicability, economic significance, for instance. But novelty, inventive step are one of the major criteria. So what patent office does is search the novel and inventive criteria and industrial applicability, and then if they found something which is relevant to your patent applications, they will give you the examination report, uh, and it is called the first examination report, which is being issued by the patent office. Now, once you receive the examination report, you have to file the response. So, if the patent office has given that this feature is already existing in the prior art, which they will cite with the prior arts, example, cited documents D1, D2, D3. These citations can be both patent and non-patent literature. Now, based on these citations, you prepare the response, uh, and then the patent office again go through the response that you have filed, and then what they do is once they go through the documents, if they find that it is a satisfactory response based on the objection which they have raised, they will either, what they will do, they will accept your patent application. They will grant, accept, or grant the patent application. But for instance, if the after going through the response that you have filed, the patent office has some, they are not satisfied with your response and they need additional information. What they will do, they can issue a hearing notice. So once a hearing notice is issued, you will make your representation, explain the invention to the controller or the examiner that this is the specific novel and inventive feature in your invention, and then you can differentiate the features which has been already existing, and then based on the hearing you make a submission, and if the controller is satisfied with your response, they will either grant or reject the patent applications. Now, this is the complete life cycle of filing and prosecution of the patent applications. And when the patent application is granted, you have to renew it after a certain period of time. You have to file a renewal application, and this period of patent is for 20 years, and you have to renew and file the renewal fee at the patent office. So, this is uh, the basics. I have given you the basics of patent filing and prosecution of a patent application. Now coming to what can be contents of patent application. So when you are writing the contents of patent application, so I am taking example of complete patent application. So you have to write the title of the invention. So example, if you've developed a robot, for instance, a robot for cleaning. So what can be title? The title can be cleaning robot. Title can be robot for cleaning X, Y, and Z, or can robot for cleaning glasses, robot for cleaning floor, robot for cleaning what, robot for cleaning. So you might have different title based on the based on the utility or based on the nature of the invention. You may have different title for the inventions, which should precisely indicate what is your invention. Now, field of invention is you have to give the technical field, that what is the field it relates to. Like field can be a cleaning robot, more particularly relating to a robot for cleaning glass, because this robot you have claimed a robot, but the field of the robot is this robot will be specifically used for cleaning of the glasses, for instance. So this is one of the field of the invention. Now coming to background of the invention, what you have to write in the background of the invention is you have to explain the existing prior art based on your knowledge, and what is the background, like what was the genesis of this invention, why you thought of this. So you might have different backgrounds. So for instance, robots can be small robots also. Say if you see a high rise building wherein they comprises of glass, so it is not easy for a owner of a house to clean the outer window. Okay. Or there might be some other earlier inventions which may have a remote control for cleaning a, say, a glass window, but those were not easily that cannot be easily operated. So you can explain that this was the patent application or this was the prior art which discloses the cleaning of the window, but these are the drawbacks. Okay. Now these drawbacks you are going to overcome. What was from the background, these were the already the drawbacks, and from your invention you are going to overcome these drawbacks, which is having a technical effect. Okay. So this is something which has to come in the background. You don't have to explain your invention, but background has to explain why. What was the reason, what was the earlier part, how you say example, there were different robots or cleaning, but these were the specific drawbacks, or these were not having these specific say operability features, or these robots were not easily able to be managed by the owner, or these robots does not have a proper cleaning mechanism. So these can be a background information. Now coming to summary of the invention is you have to provide your summary. The invention that you have developed is say a cleaning a glass cleaning, a robot for cleaning glass. Now you, and summary of the invention, you will write a robot for cleaning glass comprising of X, Y, and Z features. So you will give a description in some words that these the summary you will explain in few words what is your invention. Then coming to the next point is the descriptions of drawings. So what is the description of drawing? So once you have developed a product, so it will have a specific elements which will be interconnected, and you might sort protection on a specific way of working these two elements. Now it is better to provide a drawing so that the controller or the examiner can easily understand how what is the mechanism of operating your product. So drawings are generally included in the patent application to illustrate your invention in a very detailed way. So you will put the drawings, which will be a addition to your the specification part. Drawings for the inventions, and then coming the next point is description of the invention. So what is the description of the invention? You have to, earlier you have provided, if you look into the sequence, earlier you have provided summary of the invention. Summary is only a gist of what is the invention. Now you have to provide a detailed description of invention. You have to explain each and every element, how the each element is being interrelated to each other, how these elements are working together, how these elements are novel or inventive, comprised of inventive steps, how what you can give the working examples. So these are the different, so you have to explain in detail each and every aspect, because this is one of the requirement of the patent specification, the Patents Act, to fully and particularly describe the invention, because it is put pro and co, because you are disclosing an invention, you are getting a patents right. If you don't disclose it, you will not get it. So there may be a possibility wherein you don't want to disclose the technology of your product, and you want to keep it trade secret. So, for instance, you may see that the Pepsi or Coca-Cola, they have their recipe as a trade secret. They haven't disclosed the of uh, drink. One of the ways, if you have good command, you decide production because for 20 years. You have a if you keep it secret, trade secret is something which is not you don't disclose it to government. You have to keep it secret within your business organization. So once you decide to keep it secret, it can be made for lifetime. So there are certain companies who they, as I've given you example, the Coca-Cola, they haven't filed for patent application. This is their trade secret. Now it depends on how. So once you have filed for a patent application, the description of the invention you have to fully and particularly describe your invention. Now these are the specific description requirement of the patent application. Now coming to the another aspect is claims. As we've previously discussed, is once you file the patent application, it features or you have to define the boundary. So boundary of your so there are so you have given the description, but claims is something for which you get a patent protection, and claim is going to define the boundary of your patent. So claim is a you in the description you might have disclosed feature X, Y, Z, L, M, N, O, P, but what you're going to claim is only three features X, Y, and Z because you think that novelty and inventiveness reside only in the three features X, Y, and Z. So you will find. So you will write. There may be any number of claims. So one claim is a robot for cleaning glasses having feature X, Y, and Z. Now again, you may make some dependent claims. A cleaning for glasses as claimed in claim 1, wherein the features X comprises of A and B, C, A, B, and C features. Now you can make another claim which is dependent claim on claim number 1, which is a cleaning a robot for cleaning glasses, wherein the features Y comprises of L, M, and O features. Now you can mix multiple dependent and other independent claims if you have different aspect of doing a patent. So these are subject matter of patent. You define a boundary within which you are going to restrict your patent or your rights in a patent protection is under the claims. Now, once the claim is done, so claim is the heart of the patent application. So, claim is something which defines the boundary scope. So, the complete say say emphasis should be done on the which defines of your patent applications. Now, coming to the abstract, define title of the invention and give a brief description of inventions, and then you will add the drawings because earlier you have given an introduction of drawings and then you will attach the drawing. So this is the complete say requirements of filing a complete patent specification. So I'm just giving one of the example is patent related to a syringe device. A simple example of syringe is a device. So what we do is one thing is we have done is we will conduct a prior art search. So what you do? So either you can do any. There are multiple databases where you can go and see what type of say example in this we have done using the Google patents, if I'm not wrong, and then say syringe, you will put syringe, they will have a multiple patent application with regard to the syringe, and then you can go and explore what are the features that are already present, how your features are different or can be distinguished from the prior art. So this is one of the criteria for doing this is one of the reason for doing a prior art search. There may be another reason for doing the prior art search, which is called by different name, to define a white space. For instance, if you want to develop a new invention relating to, say, um, cybersecurity based on artificial intelligence. So this is one of the upcoming areas wherein you want to do conduct a research and file a patent application. So you want to see how artificial intelligence is being used in cybersecurity. Okay, so you can you can conduct a prior research. You can see how are the different who are the who are the different players in the market who are conducting who have already filed a patent application or who are doing the research. So this can be one of the reasons why you conduct a search to determine what are the areas under which the patent has been already filed, and this is the gap which has not been yet addressed. And by specifically investing or doing R&D in this specific area for which no patent has been filed, you can have a specific patent application. So these are the reasons why people conduct a prior art search. Even to find a new or upcoming areas, people conduct a search. Okay. And then we have the Indian patent database where you can put the search strings and you can conduct a prior art search wherein you can say go through the patent applications that has been already filed at the Indian Patent Office. So this INPAS or Indian Patent Office database is specifically only for Indian patent application that has been filed at the Patent Office. But the patent when the patent application is examined, it is a global search that is being conducted. So normally, if there are free database, we use WIPO database, WIPO patent scope, or we can do eSpaceNet. We can use USPTO search database or Google database. These are the open source free databases which are available prior art search, or we can if we are planning to see what are the white spaces under which we can conduct we can conduct a prior art search, or we can go and do a new research. We can go and file a patent applications. So these are the different areas. So based on the search, you can conduct different analysis for going ahead with patent application. So these are the once you conduct a search, you will see how say a different say we have done a conduct for syringe. So you will see the earlier application that has been filed at the patent office is being shown, wherein you can see if you can see the invention of the title and injection guide, publication when it was published, date of publication. We'll see who is the applicant. It is like nursing and Krishna Hospital. So this is in Maharashtra, which is filed for the injunction guide. So this is name of the applicant and the address of his some technical institute or nursing institute have filed for this patent application for injunction guide. So you can go and see like say in the this is for specific to Indian patent database. I have shown you an example wherein you can see the details that this patent has been granted, and all the details you can access, and these details are open. You can access, anyone can go and access it. And as I have discussed in the last, so this is one of the designs under which the syringe designs. So that is the requirement. Like say, it is not a mandatory requirement, but you can go and file the uh, design of the product for which you are seeking protection. So they have filed for a specific. So you can see their angular part, how this range can be operated and everything. So they have explained it by the way of drawings. This is an example of the WIPO patent scope database, wherein you can go and conduct search, and then you have different analysis and filters. through which you can perform your analysis. This is thank you. So this is from mind. If you have any queries, do let me know, and then we can discuss. Yes, ma'am. Yes. Yes. Hello. Yeah. Yes. Why it is known as? Because it is creation of your mind. That is, if you look into my first slide, what why it is called intelligence, but something which is created by your mind, something which you have thought of and created it. So for instance, if you write something, so literary works, example, you are writing a book because it is creation of your mind. So that is what called intellectual property, right? Something which is physical, it is under say land, so it is not called intellectual property. It is a general property rights which you can license, assign, and transfer. So if you're owning a house, so you can give it on lease, you can give your own license, you can sell it. So these are the rights associated with your physical rights. But something which you have created by your intellect is some which is called intellectual property rights, and you can get a different protection for depending upon the categorization. You have a different protections under the. So if it is technically, if you've developed something technical which involves novel and innovative features, it can have protection for under the Patents Act. Say, so if you see something like you go and buy some, say clothing, for instance. So you will see that you will go clothing, you will find a specific design related to a specific brand. So example, if you go for a Orilla brand, you will have specific designs. You will not find that a specific design in other brands or W brands. So these designs may, it is not that always they file a subject matter of protection. These designs is a subject matter of Designs Act, and they might have file protection under the Designs Act. And since these designs are creation of mind, so we called it intellectual property rights. Do you have any other queries, or you have any doubts? You can just let me know. Yes. Good afternoon. Scope. So, what is the specific query? Can you just repeat? Can you repeat your question? Scope is it depends upon, like, say scope means, say, for instance, if you take for patent protection, so what is by meaning of scope is not something that you can easily give by way of example, but something scope means what are the right associated with you. So scope can be different for a specific IP rights. So for example, technical, say for patents, scope can be for say claims. What are the claims, and based on the nature of claims, you can define what is the scope of your right. That is on patent. In trademarks, the scope is for when you are doing in the commerce, what is your rights, because no one can copy and use your trademark. So this is their scope of rights in uh, trademarks. Now coming to designs, the scope of rights is, say, if you have seen a Bisleri bottle or a Coca-Cola bottle, or say example, if you're wearing a wristwatch, or say taking a daily example, if you're coming with Maruti Suzuki a car for Swift or Desire, you will not find any other car having the design of a Swift or a desire. You will not find say anyone else copying the design of Mahindra Thar, for instance. So their scope is the aesthetic look and feel, how the product looks, and based on each IP rights, your scope are being determined. So why you see the each vehicle manufacturer have a different design? Why don't they copy it? So Scorpio, for instance, Scorpio is one of the leading four-wheeler cars which is widely sold in India. Why can't the Maruti go and copy the specific design of the Scorpio of Mahindra and make their own Scorpio and sell it? Because the design is, for instance, they might have filed or not. That is subject matter of see analysis. But as per generally, you will see that that is because they have their own design protection, and that is the reason why Maruti can't copy the design of the Mahindra for their Scorpio brand cars and cannot copy it. So for each specific right, they have different scope of protection. And that is, for example, you might see they have brought up Zimi. Why? Because Scorpio is already there, they can't copy it. So they have their own specific design and they are selling it under the Zimi brand. So each right have different scopes, and based on the nature what you seek protection for, you can file for say a protection under the Designs Act, Trademarks Act, Copyright Act, or Patents Act. So depending upon what is the nature of right, you can file a say uh, any of the rights under the Patents, Designs, and Copyright Act or Trademarks Act. Yes. Good afternoon. I can't hear your voice. So, patent is, say, if you develop something technical, okay. For example, there may be a different batteries for as I have given you example just to explain you. So there may be a specific battery which may be working for 300 kilometers, but technically you've done some changes. You might have made some chemical formulations. You might have used some new devices. You might have used a new way of equipments, technical equipments, which which enhances the working of battery from 300 kilometer to 700. Now, what you've done, you have done a technical contribution on it. That is a subject matter of patents. Any invention, because this is an invention which it is related to a technical field, and then you get a patent. What comes to say copyright? Copyright is something which is literary and artistic work, for example. So they have given what are the subject matter which correspond to. For example, literary, artistic. Example, computer programs may be a subject matter of copyright protection, cinematographic films. So once you see copyrights or patent acts, you will understand that in the copyright act they have defined that literary and artistic works, cinematographic works, any paintings. So, for instance, paintings, 3D architecture, these are subject matter of copyright. So this is the basic difference between the Copyrights Act and Design Patents Act. And similarly, if you use something in, just to go ahead and explain you something, if you use in course of trade, some design, say like if you design made a mark A, B, and C, okay, in a specific style you have written ABC, uh, and you want to use it for the commerce purpose, for using your branding ABC as brand name. So what do, you because since you're using it as a source indicator, it can be a subject matter of trademarks protection, even though the copyright may exist in the artistic work. For instance, a dual protection can be done. So it depends upon same thing, can be one thing can have multiple protection under the different acts. As I've given you in an earlier example, a robot, for instance. Okay, so robot may have some technical features of different working together. So you will have this robot, some specific technical feature, you will get a patent protection. Now this robot is having a specific design, which is having a static look and feel. So one you have for technical things, you have filed a patent protection. For look and feel of a robot, you have filed a design application, and you are selling this robot with a specific name as say example Zozo example we have told. So this robot Zuzu will have the Zuzu world can be a subject matter of trademarks protection. So these all rights are very much interrelated to each other, and depending on what is the nature, what is your say criteria or your requirement for seeking a protection, different acts can be applied for protection. If you have any doubt, let me know. Is this clear? Yeah. Yeah. Yes. 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 Sure, man. Yeah. Thank you, ma'am, for inviting me. Yeah, ma'am. Yes, ma'am. Thank you, ma'am. Thank you, ma'am. No, ma'am, if anyone has any queries, I will give my email ID to Shiv sir, and then if they want have any clarification, they can send me an email or they can call me. Okay? Yes. Yes, ma'am. Thank you. Thank you, ma'am. Thank you. May I leave the meeting now? May I leave the meeting now? Can I end the meeting now? Yeah, thank you, ma'am.